Hello, everyone. Welcome to the first episode of the Turnaround Table. I'm your host, Tejas Sudhakarki, and today we are diving deep into an important yet overlooked topic, the social costs of insolvency. When a company goes insolvent, it's not just the legal or financial event, it has real world consequences. Employees lose their jobs, small creditors struggle, and entire communities feel the impact. But how do we balance business resolution with social responsibility? To help us break this down, I am joined by Pooja Bahry ma'am, an experienced insolvency professional and who has been at the forefront of handling complex insolvency cases. She brings a wealth of knowledge and expertise on how insolvency plays out in practice and its far reaching effects beyond the courtroom. So let's get into it.
Hello.
Hello,
Good evening.
ma'am.
How are you?
Good evening.
Yes, very well.
I'm good, ma'am.
Please.
How are you doing? Yes, ma'am. Ma'am, so today we can start with discussing, like, as this is the first episode, like, of course, in this podcast, I want to get more deep into why does insolvency matter and what are the developments that are happening, and so what are the economic impacts, not just the legal side but also the financial side and the economic side and the sociological side, the perspectives that come with insolvency. So that's
Okay.
the aim of this podcast. So it's not just
Okay.
limited to insolvency. It can go from insolvency to corporate law,
I
governance,
I look I look
ESG. So
I look forward
everything
to the
that pretty
podcast
much
then,
interesting.
definitely. Lovely.
So today, ma'am, like we can start off with like
Okay.
why does insolvency matter, and why is it important that we address it the right way, and also get into why every country has its own way of
Right.
resolving insolvency, and what will be
Okay.
the
So
economic
now,
costs
why
of
does
it. Yes, ma'am.
insolvency, in fact, more than insolvency, I think this is resolution which matters because we have the insolvency in bankruptcy code.
Yeah.
But I think the definition, what everybody is, forgetting, that it is actually to revive and to resolve distressed companies. And this is when we're talking about costs and economic costs, social costs. That's something we'll, of course, come back to later. But we need to understand that the insolvency and bankruptcy code, which came in India, has been a complete transformational legislation in this country. We need to understand where we were standing at the point when this insolvency law came. Our country had a huge balance sheet problem. The banks were in a very distressed state. The NPA levels were extremely high, and that is the most important. There was this when this insolvency and bankruptcy code in India came. It was a transformational legislation. It had actually brought about a new era in financial dispute resolution and how to also increase operational efficiency. We need to, it has actually fundamentally altered the paradigm through which the businesses actually viewed restructuring, how they viewed resolution. It has significantly impacted various sectors across the country. I think it was a much needed legislation at that point of time. Of course, we are now 8 years. It's a legislation which is transforming. Every single day there is, it's an enabling legislation. Whenever there are issues, they come, and there are so many amendments which are happening in this law. But most importantly, it has brought about a new era of transparency, a new era of fairness, and it has also brought about a lot of equitable treatment of stakeholders. I won't say equal treatment, but yes, equitable treatment, which was extremely required at that point of time. And one of the reason when you said that why we needed this insolvency regime and vis-a-vis the other countries, in India, it has brought about an complete behavioral change between the debtors, the creditors, and how people are looking at insolvency and resolution has completely transformed. So it was a much needed legislation. It has actually brought about a proper a reorganization of the entire economics of our country. It was at that point of time really needed. much needed at that point of time. And when we're talking also about why we needed it at that, and what changes have brought about, there have been a lot of cultural shifts also in the dynamics, between the lenders, the creditors, the borrowers, and this is something which was required. So yes, it has been a breakthrough reform, much needed behavioral change, and I think one of the most successful legislations of this government. That is what I truly believe.
Ma'am, what I understand from Insolvency Bankruptcy Code 2016, the major shift has been from uh, liquidating the company or enforcing the security. We are first trying to resolve the company. For the sake of our viewers, like even who are not aware about the insolvency ecosystem, ma'am, could you just please throw some light on like what was the earlier regimes and what was the
Of
objective
course.
of
So when the
IBC?
earlier regimes were there, there was a lot of efforts have were being made to resolve the non-performing assets, the stress assets. There were various laws, but when IBC came, it was primarily a consolidation of all the laws. So it was never a code. There were different acts. So, there was an act when there was for the DRT, then there was this Tracy Act, wherein, the banks used to attach the assets which were mortgaged to them and just recover from them. So it was more, all the earlier tools were primarily for recovery. So when the IBC came, it was one of the first legislations to actually come for resolution. With the primary objective of the Insolvency and Bankruptcy Code was first to try resolving the company, get it back on its feet, and liquidation was definitely the last resort. Even today, I mean, there's a lot of jurisprudence which is formed under the Insolvency and Bankruptcy Code. So even today, liquidation, they say it is the last resort. So every step is being made to ensure that resolution happens, the company revives back, because there are too many people who are dependent on successfully reviving back the company. There are employees, there are workmen, there are operational creditors. All of them are dependent that that particular company continues. So this legislation, there was when it came, it was the first legislation to ensure that revival is of prime importance. And in fact, there were so many amendments which have come in this particular code. Earlier, there was, the focus was on recovery. There were multiple laws. The debtor used to be in control. Then, the timelines were not strict at all, initially pre IBC. And of course, one very important aspect was the government dues, the crown debt, you could say, had priority. So when the IBC came, so it was a complete paradigm shift, complete. So, what was given importance was resolution. And if resolution does not happen, then the company would go into liquidation, and only it would want to send those companies into liquidation which were completely unviable. So where the company was already unviable, and that is the time when the liquidation was a last resort, and which is now happening in a lot of cases where the assets are not there, or there are certain intrinsic issues in the company. So IBC, when it came, it became a comprehensive code where everything was in a proactive manner. The creditor was in control. The creditors who had given the funds, the banks, they are the ones, or the credit committee of creditors, they are the one who takes the major decisions. And one of the most important aspects is it has to be in a time bound manner. So it stressed on value maximization. IBC stressed that there should be maximization of value to the stakeholders in a time bound manner. So basically, that's why they said that, IBC was complete change. Earlier, the Provincial Insolvency Act was there, the Companies Act, the SICA Act. So all of them were, just acts. Now this is a code which is a complete code in itself. Most importantly, it has an overriding effect. So the IBC is a code which overrides the other acts, which had come in. So it was extremely important for it to come as a code, so to come as a complete change in, a complete change in the economic scenario of the country.
Ma'am, there were two interesting
Right,
things from what you said. One is the resolution, and the second is the debtors are no longer in control of the company, so it's the control is moving to the creditors. Ma'am, resolution, if I am understanding it right, they are
right,
normalizing failures
right.
of a business. And even how I see IBC as a code that allows business failures. Not business failures, but probably financial failure. Because that's what allows uh, entrepreneurs to take risk, normalizing
Yes.
that a business might fail. But on the contrary, ma'am, the creditor in control model, aren't we saying that debtors, management, the board of directors, you messed up, so you are no longer in control, and creditors are coming in. So the stigma that is associated with insolvency is, but IBC tries to resolve the stigma that is associated with insolvency. But when debtors are being removed, that stigma goes with them. That because of them that fail.
The fact of the matter
What do you
is,
think about this, ma'am?
it not all insolvencies are which could be controlled by the debtors. There are external factors. There could be when there was change in technology there, and that is the reason IBC code came. So basically, when it came, it thought that it is will be a firstly a beneficial legislation. It will put the company back on its feet. So instead of being a recovery legislation. So yeah, yes, the creditors are in control, but they are not taking decision only for themselves. Here, the financial creditors are taking a decision, but they have to think of each stakeholder. They are not there just as a recovery mechanism as it was in a SURFACE or in a DRT Act. Here, they are thinking about actually putting the company back on its feet. So that, and here the primary importance is company, number one. And second was, of course, resolving the NP issue. And in a way, where the directors were there, they were somewhere or the other responsible for putting a company in a position where there is a default, where there was huge NPAs, where the country was actually failing. The company's banking system was failing. So that was a very grave time
Right.
in 2015-16 when we actually got the particular, I mean,
Hmm.
that point of time, the NPA
Yeah.
levels were huge, and now they've come down to about 2 point something percent.
Yeah.
Yeah, so you from yes from
Right.
11%.
From
In fact, it was
11%.
more than 11% at a particular point of time. So
Hmm. Hmm. Hmm.
when you say we are pushing the debtors, the directors out, that is not true, because yes, there is a section 29A which says that yes, where there is ineligibility of resolution applicants, but the government has thought of section 240A also, which is for MSMEs, where if you are an MSME
Hmm.
promoter,
Hmm.
you are a genuine
Right.
promoter of an MSME company, there you have the option of coming back and getting back your company. So it's not that you've been thrown out by the creditors. See, the creditors are there because certain decisions may not have been taken by the directors at that particular point of time, where the company went into default. Now the creditors, they try to revive back, get a resolution applicant, and even the erstwhile promoters can be resolution applicants, where they do have the leeway of section 240A read with the 29A, where the MSME genuine promoters, as long as you have not done a fraud or you're not a willful defaulter, then you still have the option of getting back your company. Also, keeping this in mind, the pre-pack insolvency was also brought about by the government, wherein if you are an honest, promoter, you could give the initial, the base resolution plan, and where there is a P package, though of course it has not been extremely successful in the country because of certain reasons. But the fact is, it was there. The legislation was there. It still is there, and I think the intent of this law is not only to just revive after default. You have to understand a lot of cases have been settled, been resolved even before being admitted into the insolvency. So what is happening, those companies where early detection of default is being done, so because of that early detection, the companies are not, many companies now you would see are not actually slipping into the category of NPA, are not actually going into insolvency, and they are taking corrective steps initially only. So I think it is, that's one change which has that is the breakthrough reform. The fact is not only that those companies which were failing have been tried to be revived back, but also those companies which you could say were on the threshold of failing have actually come back from to not failing. And that's the much needed change which our country actually needed. I mean, and if you are an honest promoter, you always have the option of also competing to with the other resolution applicants to get back your company if you feel you can do that. Yeah.
That's interesting, ma'am. Ma'am, coming to
Okay.
Section 10 applications, uh, why do you think there are such low Section 10 applications being filed in India when compared to US? US still follows the debtor in possession model, but I believe, if I'm not wrong, most of the applications, in fact, very few are filed by the creditors, and most of them are filed by the
Right.
debtors themselves. Do you think this is because of the social stigma that is associated with insolvency, or in your experience as an IP, when the code started and we being in 2025, do you think the social stigma has reduced with respect to
See,
insolvency?
social stigma is a part which has been associated with all insolvencies throughout the world. It's not only with India. I mean, India just came,
Right.
the insolvency law, recently, you could say 7, 8 years is not very, far back. But the fact is, yes, there is a certain amount of social stigma which does get attached when, a company goes into insolvency. And because that is also in India, whether it is in India or US, the models are very different in reviving, in resolution. Of course, and ours is mostly based on the UK models, as you're well aware of, creditor in control. But
Right.
I think what we needed at that point of time was the creditor in control model. And even today, I think it is a very successful model because, the creditors are those who have taken the decisions, who have taken very, good decisions in these 8 years to revive back companies. And if you look at the statistics, we have huge number of resolved cases, huge number of settled cases. You can't even compare with any other jurisdiction which is as younger legislation, wherein we have lakhs of crores of NPAs, non-performing assets, which have actually resolved. So yes, there is a social cost there. I mean, there is no denying that. How, I mean, and that is, but that is not only in India, that is everywhere. Stigma and shame is something which is culturally there, that that you have not been able to actually your company is being pushed to towards failure, and it is actually often seen as a personal failure. And yes, there is a social stigma, but
Right.
then there are two three things. Firstly, in India, the personal insolvency law is also now coming. So where it, yeah, so that is also there.
Right.
It could be, the costs are there, but we can mitigate the social costs, of insolvency if there is early, detection, if there are early warning systems in our country, which we have. So that would help to minimize the social impact of insolvency. Also, if if they say that, if it's in all countries, they say that if you have an efficient insolvency process, that would promote quick and transparent resolution or liquidation, that would help actually minimize this social stigma in the stakeholder. So yes, we will have to take steps to reduce the social stigma in our country. One very important aspect is teaching teaching about this law. There are not many people who are actually aware about what the law is. When,
Right.
like I said, everybody talks about, the first question is insolvency. So we need to tell them it's resolution. If we are not talking about insolvency,
Mm-hmm.
we are there to revive. So someone asked me, "Are you an insolvency professional?" I said, "No, I revive back companies." So that is itself, that's a change which we need to teach. So there is a very important need for financial literacy with respect to this insolvency, what has come in, because, and I think that is, we need to educate the public. We need to educate the public that the insolvency laws in India also can be used in cases, whether it is a Section 10 case or you file an 94 application. So I mean, um, uh, it's obvious that there is a social stigma, and it's not there only in India, it's there throughout globally. And there is always a negative impact. But the fact is, if we teach properly why the insolvency law was there, why was it formed, how it can help you, how it can actually help you, if you business failure is normal, and sometimes it is beyond your control. So we will have to
Mm-hmm.
understand, but then there is a
Correct.
distinction between deliberate business failure and between business failure which is genuine.
Correct.
So that
Mm-hmm.
is something which will evolve over time. I think that is what the government also intends to do. The law also, the legislature, the jurisprudence also is, I think, which should be formed towards normalizing business failure, normalizing business
Mm-hmm.
resolution, and if it is an unviable business, to finally liquidate it. So giving an option to exit. Also, this IBC, when it brought about, a lot of people talk about resolution, but liquidation is as much a part of the IBC, wherein if there is an unviable business which cannot be revived, it should be liquidated. So that is actually ease of
Mm-hmm.
doing business. Ease of ending also is basically ending when you
Mm-hmm.
cannot actually control. So
Right.
yes, it is, the IBC can address the social causes also. It can do that. When the individual framework is very
Mm-hmm.
important. When we are talking, though of course it is still evolving, it is going to take some time to finally evolve. But yes, I like IBC, of course, has provisions of personal insolvency to manage their debt, to get a fresh start. There are fresh start provisions also given. So, though not very widely used, but they can be used. We need to just teach properly, right?
I
Most
think
important.
education is the key for this. And also one more thing that I would like to share is, so my earliest memory of insolvency. So basically, in my hometown, if any person went insolvent, an insolvency petition would be filed, and the court wouldn't give them a prefix, but the people around them, let's say the person's name is Rakesh, they would start calling him IP Rakesh.
Right.
Okay, now the IP
Yes.
is insolvency professional, but early on, that's the earliest memory of me trying to understand what is insolvency. And immediately, when I was a kid, like probably when I was like 12 or 13 years old, I felt like, oh, being insolvent is a bad thing,
Yes.
and you did that deliberately. It's ironical that I'm trying to become an
Right.
insolvency professional today, but I do see a major shift in that. Uh, Ma'am, like now that you have been practicing as an insolvency professional for
Eight
all these
years.
years, if
Yes.
I'm not wrong, almost
Eight
a
years.
decade. Uh, so, ma'am, yeah. So, how do you see? Do you see from the time the code came into force? Of course, the code was new and now it's mature to some extent.
To a
Honestly,
great
I believe
extent.
to a great extent. Do you? Yeah. So, do you think that the stigma associated with insolvency is reduced from the time you started, or what has been your personal
Okay,
experience?
truthfully, the stigma has reduced. There was a point of time when not many people understood
Okay.
the insolvency and bankruptcy code.
Hmm.
Now, most people, they understand what IBC is all about. In fact, when I started my journey
Hmm.
for stress assets management, not even anybody knew what an NPA was. I mean, there was a point in time. This was maybe
Hmm. Hmm.
2002
Hmm.
and three. So they didn't even know what a non-performing asset was. Now today, everybody even knows what an what IBC is, what insolvency is, what resolution is. I mean, we are actually
Correct.
making headlines every second day in the newspapers. Some for good reasons, some not for very good ones.
Right.
But yes, the social stigma has reduced to a certain extent. Um,
Hmm.
but like I said, there are a lot of gray areas. Now, those gray areas, sometimes a law is a very
Hmm.
beautiful thing, but it can also be misused. When a law is misused to a certain
Right.
extent,
Absolutely.
and then that misuse of the law
Hmm.
does come in the papers, or and when people talk about it, so then you again start thinking that how to plug those gray areas. And I think that is what has really happened over the
Hmm.
years. IBC has transformed whenever there has been a gray area. There have been amazing a number of amendments which have come. Please see, I mean, and if a law was being misused, the gray areas, the loopholes have been plugged. I mean, the government has been extremely, in a way, as soon as they realized that there was a need for any kind of change, that regulation came to make that change. A change in the code came to make the IBC a better legislation. So the jurisprudence has evolved a lot. The socially also, the stigma has reduced, but the fact is not many people are well aware of what would happen in the personal insolvencies, because most of the social stigma is referenced
Right.
personal, because when it's with reference to a company, the company
Right.
if, again revises back, when you're talking about
Hmm.
social costs, the social cost is not only for the directors. There is a social cost for the people who are working, the
Yeah.
people who are the employees, whether if that company, I mean, there's one way of looking at it, that only for the cost from the the promoter's point of view, the director's point of view, the social stigma that this was his person's company, whether it's gone into liquidation or resolution. But if that think from the point of view that if that company had not revived, then all the employees who were
Hmm.
working there,
Hmm.
their families, hundreds
Correct.
and thousands of families would have been affected. So think of the social cost that would have caused. So the social cost of any company closing down, of any company going into a non-performing asset, it has huge cost for the employees, for their families. There are so many cases where the gratuities have not been paid for years, the PF has not been paid for years, where the workers have not got their complete salaries. So I think IBC came as a boon in those scenarios. So and if those companies had gone down and those companies had closed, then think of the social cost of the families which would have been there on those employees. They would have, of course,
Hmm.
lost
Hmm.
their livelihood, their jobs. The fact that operational creditors, when a company closes, there are various people who are dependent. Your suppliers are dependent on you. The people whom you are buying are dependent on you. So there are hundreds of people in the chain, in the business chain, who are actually dependent on you to keep your company successful. So I mean, think there is, when you think about the social cost, that social cost which is being addressed through the IBC to keep that company going, revived, those employees having their jobs, for they've worked years in a company to get their gratuities, their pending PF, it's a lot. It's a lot. So
Correct.
yes, I think
Hmm.
social cost is for everybody, every person who is involved in the ecosystem,
Hmm.
including the promoters, the directors, the employees, anyone who's connected. I think IBC has um, really tried to change the mindset of the people, that yes, revival is possible. If revival is not possible, then anyways those companies would be pushed into liquidation, which were anyways maybe not running, or anyways those companies already had a history
Right.
of being in the BIFR for years, their assets already stripped, and nothing left in that company.
Hmm. Hmm.
So then those companies are primarily those which are actually pushed into liquidation. But yes, social stigma has reduced, and I think
Yeah.
right. So we all
Yes,
actually
ma'am.
have to work. We all have to continue to work to reduce the social stigma which is attached. And I think that can only come through education, various awareness programs, educational programs. And I think everyone is taking steps. I think this podcast is also a step in the right direction, so that people understand that this code is for revival, resolution, and of course, those companies which cannot be revived would go into liquidation.
Agreed, ma'am. I wish this podcast does actually educate, and that's been one of the objective of
That
me starting out this. Many people don't know what insolvency is, the true meaning of it, and what can be its impact. So recently, I was just like lost in this chain of thought. Like, okay, let's say a company goes insolvent. Like, what would be the ripple effects? I just went on connecting, and it did not end. Like, for example, I was just thinking, okay, so a company goes into insolvency, the employees are not going to get
yes,
their salaries. So they have less money or
yes,
absolutely no money to spend. So the
yes,
consumption in the country goes down. So this directly affects the indirect taxes. There's no consumption, so there's no revenue for the government. And there's no circulation of the
yes,
money that's there from. And so when there is no consumption, government has a strain on itself, which directly gets on the financial institutions, and they end up increasing the rate of interest because
yes,
why should they take the
yes.
losses? They have to survive,
It is
and the
a
rate of
circle.
interest increases.
Yes,
So
it is a
this chain
circle.
of
It is
thought.
a chain.
Yeah.
And you have to understand, when the IBC came, there was a very conscious decision by the government to deprioritize their government dues. Please, in the insolvency and bankruptcy code,
Hmm,
who
hmm.
is given most importance? It is the
Yeah.
costs of the people if they are
Correct.
continuing the company during that period, or it is EPF dues, your gratuity is there, your creditors, financial creditors. That's the banks, because what the code intended was to strengthen the banks. If the banks are not strengthened, every single person in this country is going to be affected. And if there was any kind of concern with the banking system, it would have gone down really. It would have been good for the entire country, for the economy. And today, where we are proceeding towards, what is our next goal? Our goal is the Viksit
Correct.
Bharat. It is
Hmm.
to be a developed country. So how would we have developed that? It's a fact.
Yeah.
It is a chain, it is a circle, and every company which fails has a complete direct and indirect impact on the entire economy. And there are so many assets which had been lying unutilized. I mean, today we talk about where a company's maybe
Hmm.
was not doing well, and those companies had just idle assets not being used in the economy. Now, today, we
Hmm.
have a resolution plan which is now going to work on these assets, get them back in the economy, make them, work for our
Hmm.
country. So we had huge amount of piles of
Correct.
assets which were not being utilized. Now that it happened, and the government very, very consciously chose, when there is a waterfall mechanism in this insolvency code, and the government dues come very, very much lower on that insolvency in on that forum. So it is, I think, they are after operational creditors, they're the fifth or the sixth in line. So usually, in the government departments have taken a huge haircut. We talk about, a lot of in the papers, there's a lot of haircuts the banks take. But the fact is, the government is the one which is actually taking the maximum haircut. Why are they doing it? Because they want those assets to come back in the economy, those business to restart, to revive, resolve, and then the country will come back. We need all those companies who
Right.
had shut down or were on the verge of shutting down to actually restart their operations. This is what resolution is all about. I mean, and there are certain
Right.
companies which have been ailing since decades. So for them to come back and revive, I mean, that's the beauty of this legislation. I think I find this IBC code a very beautiful legislation because it is there to get back our economy on the right track and hopefully to become a developed nation very soon. And yes, slowly and steadily, I think the social stigma part also of it would be also reduced to a certain extent. Once when your company, see,
Agreed.
right now we have been focusing on the first 5, 6, 7 years on companies, on corporate resolutions, corporate liquidations. I think the next phase would be a lot about personal insolvency, where you're unable to pay your
Hmm.
debts, and then you can give a repayment plan, and then again come back. So that social stigma, will reduce over time. We need to give time to our legislation. We are a very incredibly young legislation. It's not very old. I mean, Chapter 11 in US has been
Correct.
for
Yeah.
decades there. And we just have what, 7 or 8 years? We're the 8 now.
Absolutely.
Yes, so that's it.
Eight
Not
years.
more than that. So we need to give time to our legislation. And we have done tremendous amount of work. I mean, I think at very small pace of time, and we Indians are very hardworking. So I'm sure we will be able to reduce the social stigma and the social costs attached also in the near future. I feel that.
My next question was going to be like, what do you mean by beneficial legislation? But I
Yeah,
think you've
thank
beautifully answered it. And I don't know how many people know it,
you. Yes.
but Donald Trump filed, I think, if I'm not
Yes.
wrong, 4 times for
And he's,
bankruptcy. And he's the president of United States, one of the
yes. But
strongest
it's
economy in
taken
the
them
world.
decades. No, it's taken them
So
decades.
that's
It's taken them decades, and we
right.
are incredibly young in this insolvency law. Still, the milestones which we have
Yes.
reached are is incredible. The people whom we have touched, the companies which we have revived, the employees who have continued. I mean, look at the beauty in those. There have been a lot of cases where there are not many employees, and where the resolution has not happened as it ought to happen. But in 80% of the cases, I mean, when you look at the studies which is there, I think I had also done a study wherein it said that those companies who have revived are doing so much better than they were doing earlier. So they have been able to be more profitable.
Yes.
They have been able to give back to the country. They have been able to give back to the economy. And I think all these companies now have, a chance to come back and to be something bigger, better,
Second chance.
and of course, a lot of less baggage. So a lot of your claims do get reduced. With less
Right.
baggage, you have a chance to come back, and those employees are right there. They are there along with the company to, and that's how you mitigate social cost to revive and resolve. That's how it will all come back.
Uh, Adding further on this, there is one controversy. There's still like some differing views on this, on the status
Right.
of the operational creditors. So, ma'am, like I understand that banks are backbone of the economy, the financial institutions. They are the ones who provide the credit. They are the ones who infuse capital into businesses. But, ma'am, at the same time, don't you think operational creditors are being put in a disadvantageous situation? Because I was just going across this case where one of the company that went insolvent, so this company's major chunk of business was coming from one company. That the company to which it was supplying the raw materials, when that went insolvent, and when during the resolution plan or during the liquidation, this company hardly
Right.
received anything. And so this company also went
Yes.
into insolvency. So, don't you think there's a chain effect by not protecting the operational creditors, or do you have a different
See,
view on
my
this one?
view is yes, operational creditors are very important. They are the ones who are going to help you keep your company as a going concern during that period. During that period, whatever is to be paid to the operational creditors is a priority, is a CIRP cost, will be paid.
Hmm. Hmm.
What will they may have and would
Hmm.
have a haircut on is your pre CIRP dues. So that is something which they were
Hmm.
anyways not getting for a long period of time. That is the reason they've gone into a claim. And also, see, we have to,
Hmm. Hmm.
in IBC, there is a very much intelligible differentia between financial creditors and operational creditors. That law has been laid down and reaffirmed by the Supreme Court. So the treatment of financial creditors and operational creditors is extremely different. Yes, they've been given voting powers, the financial creditors, and it is not only because they are the ones who've given the money. It is because, as banks, they
Hmm. Hmm.
genuinely do have the capability to take better business decisions with respect to that company. But then, like I said, the decisions which they are taking, it cannot be only for themselves. The decision which they are talking about, the
Right.
commercial wisdom of the committee of creditors, which are the financial creditors, is for everybody. The decisions which they have to take, they have to, in
Hmm.
fact, when they are actually approving a resolution plan, they have to see how every stakeholder has benefited, how it is treating every stakeholder. But yes, the fact is the IBC is has understood that there is an intelligible differential between operational financial creditors, and the only time when they don't get the money is when the assets are genuinely not there. See, when the assets are genuinely not there, or if they had a liquidation value which was due to them,
Hmm. Hmm.
the government has made it a point that they will
Hmm.
get the minimum liquidation value due to them. But to say that let them be as equal with financial creditors, it will be very tough. Then please understand, like I said,
Right.
have a goal. We have a goal to run our economy. We have a
Hmm.
goal to, I mean, and whose money is there in the banks? It's our money. Your money, your family's money,
Right.
your friends, relatives, all of them have their money. Now, if in case the banks have an issue, they are unable to pay you when you ask for your fixed deposit back, see what is the kind of costs that would be there at that point of time. So yes, we have to consider.
Hmm.
We
Hmm.
have to consider what are the assets which are available. We have to consider what is the liquidation value which is there. And but yes, I think now the government is. I mean, a lot of amendments are coming. There are a lot of operational creditors like maybe Noida or the authorities who were not a part of the committee of creditors. Now also, as you can see, even last week there are a lot of amendments that they will also be there, a part of the committee
Right.
of
Right.
creditors. Maybe if only to
Hmm.
give their view, what is their viewpoint, and also I think every committee of creditors where there are more than 10% of operational creditors. So their representative is there in every meeting. He is being shared
Hmm.
every
Hmm.
minute, every notice, every agenda. He's a part of the discussions. Whatever are the plans which come, what resolutions plans come, those operational creditors are, or at least their representative is a part of that particular meeting, their
Right.
discussions, that how it is affecting them. But then the fact is, what about assets? If there is a company which does not have the assets, so how would you do the distribution? So yes, it is there, but the fact is, among operational creditors, there are employees who are getting a better deal than everybody else. Their PF, their
Agreed.
gratuity,
Hmm. Hmm.
their dues during CIRP will be paid. Then again, their 1 year dues would have a priority over, a lot of other government departments and other departments. So yes, among the operational creditors, the employees, the workmen do have a better standing if I may say so. I think the worst is the government. The
Hmm.
government has taken a back seat, and they have the very, very conscious
Yes.
deprioritization of government use. Of course, there was contradictory jurisprudence which had come, and then sort of for about a year or two,
Hmm. Yeah.
we all were fighting battles in court, so that who gets the priority. But hopefully, the jurisprudence will be finalized soon. Yeah.
I think it's all about the macro level. Maybe being trying to at least like mostly we being a capitalist society. So looking at the macro level perspective does make sense because it's end of the day. It's when the economy
Yes,
grows, we
and
all
if the
grow
economy
together.
fails, we all fail together. We need to understand that. I mean, if we think about
Absolutely.
2015 and 16, where we were, it is unimaginable. I mean, it is
Hmm.
unimaginable that any country could
Agreed.
develop as it did. I mean, and I think
Hmm.
it's very important for us to understand how big a part the IBC has played in getting the economy back, the country back, and towards a better future, hopefully for every one of us.
Agreed. Ma'am, a couple of times you mentioned about early detection. So, what is that IBC brings into the table with regards to early detection, and how was the regime earlier? And do you think uh, that the current regime, the IBC 2016's early detection, is it meeting the
See, early
expectations?
detection is, IBC, it gets triggered when there is a default. So, and it's not necessary to become the
Hmm.
non-performing. So, before it becomes maybe a non-performing asset, but just a default can actually right. So,
Hmm.
that is early detection signal
Hmm.
that yes, the company may go into
Yeah.
stress. It may actually go into a
Insolvency.
non-performing asset.
Hmm.
And I think lot of the early detection signs help a lot of companies come back from insolvency on the verge of insolvency. What happens is there are a lot of cases where you issue a notice where a Section 9 is filed, a Section 7 is filed. That company understands and actually maybe tries to resolve, tries to settle, tries to get itself back in its position so that it does not go into insolvency. So that is a sign. And the what is more of a sign that more than most of the companies which have gone into insolvency, there are how many lakh crores? I think maybe 10 lakh crores of cases where the actual the settlements have happened, the withdrawal has happened at a pre-IBC stage. Now that is early detection. That those companies were being pushed
Right.
into the insolvency resolution process. They were not pushed into because of that. They realized there was a notice which was served to them. The applications would happen in the NCLT, and those company finally actually did not go into IBC. So, and they were able to come back. So that is one early detection sign. Then what has happened is there has been a behavioral change. Lot of now everybody does not want to get their company to the good, does not want it to go into IBC. So for them, they are making steps to improve their performance, to improve their how they are paying their creditors. They are improving the credit lines. They are actually making the payments on time. So all this has changed. IBC has changed that now all these signs, early signs, and if a company is actually going into IBC, it's now we have the pre-pack
Hmm.
is also there, and now mediation has come in. So where if there would it
Hmm.
would be
Hmm.
introduced in insolvency, there are a lot of operational creditor cases through mediation if they can be resolved before. So that is of course again an early detection. So let the companies which had already gone into stress, they are being revived back or liquidated. The other companies who would have gone into stress are not going into stress because of the fact that now they are because of this early detection. and to understand that IBC has changed the way they actually work. So that's really been very important.
Right. Mom, so you being an insolvency professional, and we today talking about the social costs of insolvency. What is it that the insolvency professionals bring into the table when a company goes into insolvency, and what is their role in reducing the social costs
See,
of
I think as an
insolvency?
insolvency professional, we are one of the most important people. I think it's a very, and it's the onus is on us to run the process properly. The onus is
Hmm.
on us to ensure that we are doing the right thing, ethically, which is morally correct, which is for the benefit of the country, and for it is actually it is the entire responsibility comes on us to collectively actually harness the potential of this code. So we are the ones who are
Right.
actually creating this thriving ecosystem, which actually is enabling value preservation. So somewhere or the other, and I think
Hmm.
as an insolvency professional, every every successful resolution requires an extra effort from us. And one which we need to do as an insolvency professional is to build trust. I think trust is one of the most important aspects, because in a process, everyone needs to trust you, whether it is are the directors,
Right.
or there are the employees, the operational creditors, the government, the IBBI, the courts, the NCLT. So
Hmm.
all of them have actually put faith on us that we will do as we
Right.
need to do, as we be as that we are the
Hmm.
ones who they feel that our expertise, that our professionalism will actually show what would be the outcome of the resolution process. So I think as an insolvency professional, we are a very important pillar. I mean, they say we are one of the four pillars, but we actually are a very important pillar, because we need to know the knowledge of the industry, of the law properly. We need to understand the nuances of the law, very importantly, that what is right. We are the ones who are actually running the process in an ethical manner. I think that becomes one of the most important aspects, that how are we running a process? Are we doing the right thing? Are
Right.
we taking every stakeholder in consultation? I think it's a very critical element. And I think as an insolvency professional, we have
Hmm.
to ensure that we are positively impacting every person we meet, that we are actually speaking to the right people, we are speaking the right thing, we are
Hmm.
communicating in a way which needs to be communicated. We
Right.
are actually, whether it is anyone, whether it's the employees, the directors, the company people, the workers, the operational creditors, we are the ones who are actually to give them the right uh, what the law is, and we need to explain to them that how important it
Hmm.
is that uh, why are we doing this, why are we in this resolution process, that why is
Agreed.
extremely important, and what are we hoping to achieve when the company actually revives. So yes, I think that is becomes the most important aspect, that and it's very overwhelming, truthfully, sometimes, always, because there are so many
Right.
people who put faith on you to do the right thing. And I think it is very important that we uh, also do the best that we can, keep on continuing to learn every single day, and we do the best. I think we also need to develop our skills in the right way, that the social stigma is also reduced. How are we able to
Hmm.
actually explain to others? Like
Right.
I said, education again. That is when education again becomes very important.
Hmm.
That why the code is there, why it was brought about, why is it, how is it that we are going to positively impact you? Now that is extremely important. I think till we are able to express ourselves properly to every stakeholder in the process,
Ag-
I don't know how are we, we're going to achieve what we need to. But yes, that's important to do the right thing. And when you do the right thing, your reputation would precede you. Like I said, my favorite line has always been, your reputation precedes. If you do the right
Reputation.
thing, everyone knows you're doing the right thing.
I have, when you told me that, that was an eye opener, and that's something that's hit me very hard, that the
Yes.
reputation precedes you. That's something, once I am an
Yes.
insolvency professional, I would make a commitment today that
Yes.
I would follow that.
Everyone knows it, whether
Uh,
you're following it or
Mom,
not.
just
Believe
like
me.
before,
And I think as
yeah.
an insolvency professional,
Hmm.
we learn, unlearn, relearn every single day. But our strength is to actually do the right thing, which needs to be done in an ethical manner.
Correct.
Everyone, like I said,
Hmm.
everyone tries their best. Truthfully, I won't say anything about any
Hmm.
professional, or because we all are trying our best to, take this
Hmm.
process, this IBC, in the right direction, so that yes, everyone remembers IBC as one of the most beneficial legislations of this country.
Agreed, ma'am. I agree. Uh, Ma'am, before we just wind up today's episode, there's one question that's been uh, in my head since quite some time. And this was the question that me and my roommate were
Okay,
discussing yesterday as well. So probably you could
please.
throw some light and your view on this. Ma'am, where do you see IBC going, and let's say a decade down the lane? What do you think would be the changes? Do you think there would be a time where we would need a new legislation? And basically, how do you think it's going to evolve? Like, what's your future outlook on
See,
this whole?
truthfully, I think IBC would remain, hopefully for me also, a very big
Hmm.
part of the developed country which we are going towards. And it's not possible for
Right.
every business to succeed. It is a possibility. There could be, like I said, when
Hmm.
you're an entrepreneur, even business failure is something which you have to accept. So, till business failure is there, I think insolvency and resolution would remain relevant. And we need to make sure that it
Hmm.
remains relevant for the right reasons. I think the next step in the insolvency is a lot about having a very maybe robust personal insolvency law also framework. That is also something which
Hmm.
is
Agree.
there. um, Also, what is important is maybe a broader scope of IBC can be taken out, wherein where we are thinking about the social enterprises insolvency, how we are going to leverage technology further on. I mean, that's something AI is also there, and I think
Hmm.
IT is also being now going to be used a lot in the insolvency regime. I think a lot of
Hmm.
focus now would
Right.
be made on further on MSMEs. Yes, there was a pre-pack law earlier, but then now
Hmm.
MSMEs, I think, is something which the government, they do not want that sector to suffer. So if it that can be revived, so something for MSMEs is something which I'm thinking. Like mediation is also something which is now coming. Mandatory, I think pre-insolvency
True.
mediation is something a lot of people are thinking about that. And insolvency would go in the
Hmm.
right direction if we are doing proper capacity building for professionals. I think that's also very, very important. I think, a lot of awareness about insolvency needs to be done, also about personal insolvencies. And right, I said, reducing social costs, because that we were talking about today. How those stigma can be reduced in the long run is something maybe the insolvency would be catering to in the future. And I do think of insolvency being there definitely till there is business failure. There would be a need for business revival.
Hmm.
There are no two ways about it. And that's the reason the law came, that let
Hmm.
people try to be entrepreneurs. I mean, I think that is what one of the I was
Right.
hearing in one of the speeches also, that try new businesses, and maybe 10 succeed and maybe
Hmm.
5 don't. So when for those five, you would need the
Hmm.
insolvency regime, not to liquidate it, but to revive it back. Or, maybe there is somebody else who can revive that
Hmm.
business back. Or maybe if there could be a just end to a business where
True.
you, as an entrepreneur. So the push has been in this now country to, for to focus on entrepreneurship, start new businesses. That's the only way we are going to be a
Right.
developed country. So, and if we are going to be a developed country, so
Agreed.
insolvency law will have to be relevant. Yeah, and I think good insolvency
Hmm.
professionals will always remain relevant. That's what I genuinely hope, and I do hope that we have, the next generation of insolvency professionals who are very much in line with ethics and values and morals, which is the backbone of our country.
Thank you, ma'am. Thank you so much. It's
Most
been a
welcome.
wonderful session. Uh, I couldn't ask for more. This was something more than what I
Thank you
was
very
looking
much.
forward to.
No, no, thank you
Thank you
so
for
much.
that, ma'am.
It's the
And
first
thank you for your
podcast for me
time.
also. So thank you very much. It was an amazing experience, and I genuinely do hope that our insolvency regime grows in the right direction and grows exponentially for towards resolution, towards revival.
Right.
Yes, that's the
That's
goal.
the bottom
So
line.
thank you so
Thank you.
much. Thank you.
Thank you,
Thanks.
ma'am. Thank you. That brings us to the end of this episode on the turnaround table. I hope this conversation has shed some light on the deeper social impact of insolvency beyond just numbers and legal proceedings. A huge thank you to Pooja Bahry ma'am for sharing her insights. Her experience as a seasoned insolvency professional has really helped us to understand the human side of insolvency. If you have enjoyed this episode, please make sure to follow and subscribe to the Turnaround Table on your favorite podcast platform. Got thoughts on today's topic? Connect with me on LinkedIn or drop your comments wherever you're listening. Thanks for tuning in.